Chapter 7. Bankruptcy is the most common form of bankruptcy in the United States, and for creditors, it's often the most alarming. A Chapter 7 filing triggers an automatic stay that halts all collection efforts immediately, and if the case proceeds to discharge, most unsecured debts are eliminated entirely. Here is what creditors need to know to protect their interests and maximize recovery in a Chapter 7 case. The moment a Chapter 7 petition is filed, the automatic stay under Section 362 of the Bankruptcy Code takes effect. This stay prohibits creditors from continuing collection lawsuits, making collection calls, sending collection letters, garnishing wages, levying bank accounts, or taking any other action to collect a debt against the debtor or property of the bankruptcy estate, without first obtaining relief from stay from the bankruptcy court. Violating the automatic stay is not a minor procedural misstep. It exposes the creditor to sanctions, actual damages, and in willful violation cases, punitive damages. The moment you receive notice of a bankruptcy filing, or have any reason to believe one has been filed, stop all collection activity immediately and confirm the filing through PACER. The bankruptcy estate is administered by a Chapter 7 trustee appointed by the U.S. Trustee's Office. The trustee's job is to liquidate the debtor's non-exempt assets and distribute the proceeds to creditors in the priority order established by the Bankruptcy Code. Here's the creditor priority waterfall in Chapter 7. First come secured creditors, those with liens on specific property, who receive the collateral or its value up to the amount of the claim. Next come administrative expenses, the trustee's fees and attorney fees for the estate. Then priority unsecured creditors, domestic support obligations, certain taxes, certain employee wages. Finally, general unsecured creditors divide whatever is left pro rata. In the majority of Chapter 7 cases, called no-asset cases, the debtor has no non-exempt assets for the trustee to liquidate. General unsecured creditors receive nothing, and the debts are discharged. To participate in any distribution, you must file a proof of claim by the bar date, typically 70 days after the petition date for non-governmental creditors. If no proof of claim is filed, you receive nothing, even if assets are available. Your most important options as a creditor in Chapter 7: lift the automatic stay if you are a secured creditor whose collateral is depreciating, uninsured, or not being maintained. A motion for relief from stay, supported by evidence that the debtor has no equity in the collateral and the collateral is not necessary to an effective reorganization, can allow you to proceed with repossession or foreclosure. Object to discharge under Section 727 if there is evidence the debtor has hidden assets, made fraudulent transfers, destroyed financial records, lied on their bankruptcy schedules, or committed other acts that would bar a general discharge. A successful Section 727 objection means none of the debtor's debts are discharged. Challenge dischargeability of your specific debt under Section 523 if the debt was incurred through fraud, false pretenses, willful and malicious injury, embezzlement, breach of fiduciary duty, domestic support obligations, or certain other enumerated categories. A successful Section 523 adversary proceeding makes your specific debt survive the discharge. People Locator, skip tracing, investigates bankruptcy debtors, finding hidden assets, identifying fraudulent transfers, and locating debtors who file and then become unreachable. Visit peoplelocatorskiptracing.com to place your order.